Hello, everyone. Welcome to Remote Lawyer. Hope all of you are doing well. Today, we are going to talk about reviewing contracts and spotting common language errors. Now, there are simple phrases such as and, or, shall, may, etc., which skip our attention. But these phrases are the ones that may cause the maximum enforceability problems. So let us see which are these common language errors which we need to keep in mind while reviewing contracts. Now, and or and slash or. Now, which of the three phrases should you be using? Now, let us consider this clause. This agreement shall be valid for either 5 years post the termination of the agreement and till the purpose of this agreement is fulfilled, whichever is later. Now, is the usage of and right here? So when you read this clause, you would understand that there is an option being given. Now, how do you identify that? You identify that by the word either. Now, every time the word either is being used, it's an either or situation. That means there are two options. Also, the term whichever is later. It means one of the two is going to hold valid. Now, and as a phrase is a cumulative term. So, and signifies something plus something and not something or something. And therefore, the usage of and here is not correct. The correct usage would be of or. So, it should be this agreement shall be valid for either 5 years post the termination of the agreement or till the purpose of this agreement is fulfilled, whichever is later. So, whenever you are in confusion between using and or, you should always focus on which clause is giving you an option and which clause is giving you a cumulative intent. Now, the second is and slash or. Where should you use and slash or? Now, X shall indemnify, defend, and hold harmless Y against any and all claims arising out of loss of property and breach of applicable laws. Now, on a seeming reading, most people will think that this is the right wording of the clause. But the problem that arises here is that it's a cumulative wording. So what's going to happen is that, for example, uh, X has to indemnify Y for loss of property. Now, Y is going to say that claims arising out of loss of property and breach of applicable laws. So therefore, it becomes two claims as a cumulative claim and not as an either or option. If the wording or was used here, it would mean that either he'll indemnify for loss of property or he'll indemnify for breach of applicable laws. So therefore, an and slash or makes the most sense here. So for example, if X has done something which causes loss of property as well as breach of applicable laws, then he'll indemnify for both. If he has done something which is either of the two is being breached, then he'll indemnify for either loss of property or breach of applicable laws. So therefore, in indemnity clauses especially, an and slash or should be used when demarcating the grounds of indemnity. A similar usage should also be used when you are defining misconduct typically. So an and slash or clause. So because if someone has engaged in two events of misconduct, then that's how it's going to be covered. Now, and happens when cumulative conditions exist. So for example, supplier shall provide the goods on a timely basis and in accordance with the instructions provided. It means two conditions and both need to be fulfilled. Or when two options exist. So there are two conditions and either of the two need to be fulfilled. And slash or is for holistic coverage, where the intent is to cover both cumulative conditions as well as optional events. Now, inter alia. Now, inter alia means among other things. So it widens the scope of a clause. if we consider the same indemnity clause and we put this term inter alia right behind the grounds of indemnity, it reads as X shall indemnify, defend, and hold harmless Y against any and all claims arising inter alia out of loss of property and breach of applicable laws. Now, this inter alia means among other things. So, it means that X would indemnify Y among other things for loss of property and for breach of applicable laws. It does not restrict the ground of indemnity to these two, but expands its scope. So therefore, if you see such a term, now again, inter alia is an example. So there could be other language terms such as including but not limited to, or like, claims arising out of but not restricted to. So beware and watch out for such language which basically expands the scope of an indemnity clause. In this particular clause, you need to remove the term inter alia. Now, means and includes versus including but not limited to. Now, means and includes is exhaustive in nature. So, for example, if I say that, the indemnity grounds mean and include A and B, it means it's only A and B, and you cannot, by construction, say that, there's a third ground that exists. Including but not limited to expands the scope. It's indicative in nature. It shows an example of the kind of things that exist, but the list is not restricted to those events. So use means and includes when you want to cover specific circumstances and information. So for instance, material adverse events. Now, when they are being defined, there are very specific events which are being defined. So here means and includes would make sense. But if you are using, if the intention is to indicate but not cover all events, so it's not an exhaustive list, it's just an illustrative list. In such a case, use including but not limited to. Typically, definition of confidential information, force majeure events, etc. use this language including but not limited to because they indicate the events. Now, again, the language that has to be retained depends upon which party you are representing. So, for example, if you are the receiver of the confidential information and you are the one on whose confidentiality obligations are being imposed, then you would not want to use including but not limited to. You will then want to use means and includes because you would want to restrict the scope of confidential information. Similarly, if you are the service provider, then you would want to include means and includes, but not including but not limited to. Because again, you would want to restrict the scope of force majeure events. On the other hand, if you are the client, then you would want to expand the scope of force majeure events or expand the scope of confidential information. So, shall versus may. Now, again, this is something which is a very common mistake. Now, shall is a definitive term. May is a discretionary term. Use shall when you want the opposite party to absolutely perform their obligations and there is no scope of a doubt left. So the supplier shall timely deliver the project in accordance with the timeline supplied. Use may when you want to retain discretionary power. Now, in the above given clause, the usage of the term shall does not give the supplier any discretion. It doesn't say the supplier may timely deliver the project. So shall is a binding obligation. May is discretionary. So consider the example, the client may signify acceptance of goods in writing, or the parties may terminate the agreement prior to expiration. So again, the usage of the term may signifies a discretion on the part of the client or the parties. And it's not a binding obligation. So the client does not have to signify acceptance of goods in writing. Neither the parties have to terminate the agreement prior to expiration. So again, usage of shall versus may depends upon which party you are representing. Now, for example, you get a contract from the supplier and it says the supplier may deliver the project in accordance with the timeline supplied. Now, again, on a seeming reading, you may not understand whether the supplier may timely deliver is going to affect the enforceability of your obligation later on. So you should correct that to shall. Similarly, if you are representing the client and the contract says the client shall signify acceptance of goods in writing. Now, it's a standard obligation which you can accept, but if your client is not agreed to signifying the acceptance of goods in writing, you can convert that into may signify. So that gives the client a leeway or a discretion. Thank you. I hope you enjoyed this video and it was a learning experience for you. If you have any queries or doubts, please do reach out to me either on my LinkedIn or you could leave a comment below this video. Thank you and have a nice day.